Welcome back to the lecture series on employee relations and labor laws. Today we will discuss about the Shop and Establishment Act 1948 and Workmen's Compensation Act 1972. Now, first of all we will discuss about the Shop and Establishment Act. This act is to regulate the condition of work and employment and therefore, to secure maximum benefit to the employees working in different categories of establishments. Basically, this act is for shops and commercial establishments where a number of workers are less. This included hotels, restaurants, eating houses, theatres and other places of public amusement or entertainment are mainly protected by the provisions of this act. The Shop and Establishment Department is headed by the Chief Inspector, Shops and Establishments. He is and assisted by 4 Deputy Chief Inspectors. Now, to start with the any shop or any establishment where a number of workers are less, they have to go through certain formalities and they have to fill certain forms which are given as Form A, Form B and Form E. They are respectively for various formalities to be fulfilled. Now, Form A is prescribed for registration of the establishment under Bombay's Shops and Establishments Act 1948. Registration is made under section 7 subsection 1 and 4 of said Act. Then Form B is prescribed for the periodical renewal of registration certificate, say for 1 year or 3 at a time renewal is made under section 7(2)(a) of the Bombay Shops and Establishments Act. And Form E, this form is prescribed for making any subsequent change information already submitted in Form A. So, after filling these forms, these shops and other establishments, they will get registration certificate which is generally valid up to the end of the calendar year for which it is generated under section 7(2)(a). It is required to get every registration certificate renewed for next calendar year 15 days before the date of expiry of registration certificate in hand by submitting prescribed Form B along with prescribed renewal fees to the concerned shop inspector. Now, if we talk about compliances, so in this Shop and Establishments Act, we do have compliances. During the course of enforcement, the inspectors have to visit various establishments and to detect breaches of the provisions of the Act and rules framed thereunder and to launch prosecutions on defaulters accordingly. The major breaches of these provisions of the Act consist of non-regulation, non-renewal, opening of establishment before prescribed hours, closing of establishments later than prescribed hours, exceeding total hours of working, continuous working without rest intervals, spread over or not granting privilege leaves, keeping establishment open on weekly closed days and calling employees for work on their weekly offs and child labor, etc. The major of breaches of the provisions of rule are of the nature of procedural lapses such as not maintaining prescribed register for employment, leave register, visit book, not providing leave book to the employees or not making suitable entries therein and not producing requisite records, register and notices for inspection on demand, etc. These are the compliances in which they have to work. Now, what are the documents required at the time of registration are memorandum of articles of association or trust deed. Next is premises purchase agreement, list of directors or managers, then bank account opening proof and bank account number and other details, then first income tax assessment order or PAN number, date of commencement of business and BMC certification. As you know, this is under Bombay Municipal Corporation. For this act was enacted under Bombay Municipal Corporation. So, previously it was required BMC certification also. Now, we will talk about in this series only we will talk about Workmen's Compensation Act 1972. Now, objective of this act is to provide workmen or their dependents some relief or compensation in case of accidents arising out of and in the course of employment and causing either death or disablement. Disablement may be partial or total of the workmen. Now, this act extends to the whole of India. It applies to workmen employed in factories, mines, plantations, transport establishments, construction work, railways, ships and other hazardous occupations and employments specified in Schedule 2 of the Act. The coverage of this Act also to the cooks employed in hotels and restaurants. So, first of all we will discuss about various definition in this section. This is section 2, and first of all we will discuss about the commissioner. Commissioner is basically a person who has been appointed as commissioner under the Workmen's Compensation Act under section 20 of the act, who has a responsibility to take care of the all compensations related matters in the organizations. Now, next is dependent. Dependent means any of the following relatives of a deceased workman, namely a widow, a minor legitimate or adopted son, unmarried legitimate or adopted daughter, or a widowed mother. If wholly dependent on the earnings of the workman at the time of his death, a son or a daughter who has attained the age of 18 years and who is infirm. In the continuation, a widower, a parent other than a widowed mother, a minor illegitimate son, unmarried illegitimate daughter, or a daughter legitimate or illegitimate or adopted if minor and married, or if widowed and minor, a minor brother or an unmarried sister, or a widowed sister if a minor, a widowed daughter-in-law, a minor child of predeceased son and daughter where no parent of the child is alive, and a parental grandparent if not the parent of the workman is alive. These all comes under the dependent because these people, these all are dependent on the earnings or wages of the workman who has deceased. Now, next is disablement. Disablement means loss of capacity to work or to move. Disablement of workman may result in loss or reduction of his earning capacity. In the later case, he is not able to earn as much as he used to earn before his disablement. Disablement may be partial or total, and further these partial and total disablements may be further classified into permanent disablement or temporary disablement. We say like that, permanent partial or permanent total disablement, exactly temporary partial disablement or temporary total disablement. Now, disablement means as we already discussed, any disablement that reduces the earning capacity of workmen as a result of some accident. It may be temporary or permanent. Now, temporary partial disablement means any disablement which reduces the earning capacity of a workman in any employment in which he was engaged at the time of the accident resulting in the disablement, right. Next is permanent partial disablement. Permanent partial disablement is one which reduces the earning capacity of a workman in every employment which he was capable of undertaking at time of injury. And lastly, it is total disablement. This disablement means such disablement whether of a temporary or permanent nature as incapacity of a workman for all work which he was capable of performing at the time of the accident resulting in such disablement. Now, one more thing I would like to tell you that we have to take care these two issues at the time of and in the course of, at the time of job and in the course of job. In both the case in both the cases workman is entitled for the compensation. That does mean when he is doing something in course of his employment or he is doing it out of his employment. In both the cases he is liable he is eligible for the compensation. That does mean they have to prove that they were doing whatever he was doing at the time of accident, it was in the course of his employment only. Now, employer's liability for compensation, this is section 3 which says an employer is liable to pay compensation to workmen for personal injury by accident. An employer is liable to pay compensation to workmen if personal injury is caused to him by accident arising out of and in the course of his employment. This is what I was telling you, arising out of and in the course of means whatever accident occurred, it was occurred arising out of the terms of employment and it was in the course of his employment, right. If any accident occur outside the organization where he is working his personal job, he is doing something which is related to his personal life, then in that case employer is not liable for any kind of compensation. So, next is employment diseases. See, we have certain list which talks about occupational diseases and which says that if the worker in the course of employment, if he get that occupational disease out of the employment, then again he will be eligible for the compensation under Workmen Compensation Act. In occupational diseases, workers employed in certain occupations are exposed to certain diseases which are inherent in those occupations. So, in that case, in respect of any injury which does not result in the total or partial disablement of the worker for a period exceeding 3 days, but employer is not responsible if he is catching any disease from his occupation, then only he will be eligible for the compensation, otherwise not. So, in what cases employer is not responsible, this section says in respect of any injury not resulting in death or permanent total disablement caused by an accident which is directly attributable to the workman having been at the time thereof under the influence of drink or drugs. See, this is again an important issue in the Workmen Compensation Act. If any accident occurs in the under the influence of drink or drugs which employee has taken, then in that case he will not eligible for the compensation under Compensation Act. The willful disobedience of the workman to an order expressly given or to a rule expressly framed for the purpose of securing the safety of workmen. If he has done any willful disobedience, for any safeguards he has to take care of in the course of action, and if he has ignored those safeguards and any accident occurs, again he will not be eligible for the compensation under Workmen's Compensation Act 1972. The willful removal or disregard by the workman of any safeguard or other device which he knew to have been provided for the purpose of securing the safety of workmen. See, in some occupations it has been given to the workers to that they have to safeguard themselves. They have been provided with certain devices which they have to use and to safeguard themselves, and if they have willfully disregarded those devices, safety devices, and any accident occurs, in that case also employer will not be responsible for the compensation under Workmen's Compensation Act. Now, we will discuss about the amount of compensation. We will discuss about the amount of compensation under section 4 of this act, which says the amount of compensation payable to a workman depends upon basically what we study in amount of compensation is how the compensation will be decided, what amount will be paid in the case of accident by considering all the factors of accident, right, and then it will be decided what amount should be paid. So, this is the basic idea of computing the amount. Now, the amount of compensation payable to a workman depends on the nature of injury caused by accident, the monthly wages of the workman concerned, and the relevant factor for working out lump sum equivalent of compensation amount as specified in schedule 4. Now, there is no distinction between an adult and a minor worker with respect to the amount of compensation. When we talk about adult worker and minor worker, but what is decided in under this act is both of them will be paid the same amount of compensation in the case of any accident occurs, right. What we do is the basic difference will come when we consider the age of the worker. When we calculate the compensation, age will also play a vital role in the computing of these compensation amount, right. So, compensation for death. In case of death resulting from injury, the amount of compensation shall be equal to 50% of the monthly wages of the deceased workman multiplied by the relevant factor, right. These relevant factors will be different for adult workers and minor workers, right, or an amount of rupees 80,000, whichever is more. So, how will we compute the amount? We will take the 50% monthly wage of deceased employee and we will multiply it with the relevant factors, right, and whatever amount we will get, and rupees 80,000, it is fixed, whichever is more will be paid to the dependents of the workman. Now, next is compensation for permanent total disablement. See, in last slides we have studied about permanent total disablement, and partial disablement, and then we have studied about total disablement, where employee is not able to work anymore. So, what will be the compensation in that case? In case of permanent total disablement resulting from the injury, the amount of compensation shall be 60% of the monthly wages of the injured workman multiplied by the relevant factor of rupees 90,000, whichever is more. And in the same way, we have calculated in last slide. In case of death, we have took this took 50% of monthly wages of the workers, and in case of total permanent disablement, we will take 60% of the total monthly wage of the workman, and then we will multiply it with the relevant factor, and rupees 90,000, which is fixed by the act, whichever is the more will be paid to the workman, because now he is permanently disabled to work. So, and he is alive also. So, we will calculate that way only, we will take 60% of his monthly wages. Now, next is compensation for partial disablement. Partial disablement means some of the injury caused to the workman, where he has lost his finger or he has lost his hand or something like that. This is called partial disablement. So, in that case, how will we calculate the compensation? If the temporary disablement, whether total or partial, results, total or partial means total, in total disablement worker becomes unable to work, and in partial disablement he has lost some of his body part. So, he is unable to work. The amount of compensation shall be a half monthly permanent payment of the sum equivalent to 25% of the monthly wages of the workman, to be paid in accordance with the provisions. The half monthly payment shall be payable on the 16th day from the date of disablement. Now, this is something which has to be taken care by the employer, that in case of half monthly payment, he has to make the payment before the expiry of 16th day of disablement. In case where such disablement lasts for a period of 28 days or more, compensation is payable from the date of disablement. अगर ऐसा कुछ है, if this is the case, and then compensation has to be paid before the within the 28 days of the disablement. In all other cases, after the expiry of a waiting period of 3 days from the date of disablement, all other cases employer has to make the payments before the expiry of third day, before the expiry of 3 days, so that timely payment can be done. Now, compensation to be paid in due and default. As per this section, compensation has to be paid as soon as it is due. In case the employer does not accept the liability of paying the compensation, he is bound to make provisional payment to the extent of the liability he accepts. Such amount has to be deposited with the commissioner or paid to the workman. If the defaults, the commissioner may order. अगर देखिए see, if there is some issues, if the employer don't want to pay the compensation, or he don't accept the liability to pay the compensation, he has to pay that much liability which he accepts to pay. If the employer defaults in making the payments, the commissioner may order the payment of the amount with interest at 12% per year. Now, see, in this case commissioner will come into the picture, and he will take care of all the issues related to compensation in case of any accident occur in the organization, and commissioner will go through all the papers, all the issues related to the accident, and will decide afterwards that amount should be paid or not. And if he finds that employer is on fault, then in that case he can order the employer for the payment of amount with interest at 12% per year. and if the default to be unjustifiable, then the commissioner may order payment of a further sum not exceeding 50% of the amount due by way of penalty. Whether he has two issues with him, he can order the payment of amount with interest of 12% per year, or if default is unjustifiable, if the default is justifiable, then the employer has to pay the amount, all the amount with interest of 12% per year to the worker, and if the default is not justified, he has to pay the sum not exceeding 50% of the amount. Now, notices and claims. To claim the compensation, the claimant shall give notice to accident to the employer, or by entering in the notice book within the reasonable time. Every such notice shall give the name and address of the person injured and cause of injury, the date on which the accident happened, and submit the claim application to the commissioner within 2 years from the date of accident. In case of occupational disease, the accident is deemed to have occurred on the first day of disease. Defect, if any, in the notice or not giving notice or delayed application will not bar the claim for compensation. And in that case, an appeal shall lie to the High Court if the matter does not solves here with the commissioner, then the application can be put, an appeal can be put in the High Court from the following orders of a commissioner, namely an order awarding as compensation a lump sum, whether by way of redemption of half monthly payment or otherwise, or disallowing a claim in full or in part, or for a lump sum. Next is an order awarding interest or penalty under section 4A, or can be applied an order refusing to allow redemption of a half monthly payment, or an order allowing or disallowing any claim for the amount of an indemnity under the provisions of subsection 2 of section 12. The period of limitation for an appeal under the section shall be 60 days. That does mean that within the 60 days the commissioner can order, or worker can appeal in the High Court. So, that is all about Compensation Act. Today we have discussed about various provisions under Shop and Establishments Act, as well as Workmen's Compensation Act. We have studied about dependent, disablement, and then employer's liability, and the cases where employer is not liable for the compensation. Then we have studied how the amount of compensation will be decided. Then what are the compensations in case of permanent total disablement or partial disablement, or what compensation to be paid under defaults. Defaults means defaults of employer. Then how to go for an appeal in High Courts, and that is all for today. Thank you so much for the hearing. Thank you.